from Srinagar. So very important thing. Definitely here. Since I am a student of law, I have never been through this sub-article 3 of 32. But in case, for example, this is resorted to itself, Parliament enacts a law and empowers any High Court itself to
not High Court, any other court.
Any other court, for example.
It can't be High Court.
Any other court, for example, to have the jurisdiction of the kind of 32, of the kind of 32.
Supreme Court.
But in that case, since Supreme Court is the highest court of this land, in that case, would not the supremacy of the Supreme Court be at least?
No, I tell you what will happen. Because Article 32 is an original jurisdiction of the Supreme Court. Supreme Court is overcrowded. Can hardly deal with this situation. But this provision, because the supremacy is never gone, if my same jurisdiction is given to another body. If there is any error committed by that court, it can be corrected by the Supreme Court. Jurisdiction, if you share a jurisdiction, your supremacy is never carved. It is not a monopoly. It is not a patent. It's not a commercial thing. Something for redressal of your grievances. Because if it is a violation of fundamental right, why 32 is given? You can directly approach without loss of time. Though 226 is wide, it can take care of fundamental rights and other rights. But if it is a direct violation of fundamental, you can approach that court straightway without any loss of time. And if it is fundamental right violation, 226 is discretionary. If it is a fundamental right violation, the court is bound to accept it. Suppose you have freedom, I am dismissing the thing, freedom of speech is defective. You want to hold a meeting. Your freedom of speech is defective. The police is not permitting you to hold a meeting. If there is a local court where you can approach, you can immediately take the police there. Taking to Supreme Court will take such a long time. That is the constitutional famous thought like that way. But our rulers are not thinking. The Parliament is never thought of this. I don't think any discussion in the Parliament ever took place on this. This is a vital thing. You can say the Supreme Court is Delhi is distance-wise, travel-wise, cost-wise. It's a distant dream. Give us a forum here because the Constitution provides for it. And Article 38 says the state has a duty. State must. Yes.
I have two brief questions. One, as you mentioned, it is written in the preamble of the Constitution that we, the people of India. So when we talk about we, the people, is it justified? Were really people involved in saying that there were just few people?
No. It must mean the people of India. Whoever are the people of India, it can't be the people. The concept people is not frozen in time. We, the people of India, that is a perpetual. The people of India. But one more thing, the rights under Indian Constitution is not only given to the people of India, it is even given to a foreigner. The many important rights is given to a person. We, the people of India, are adopting the Constitution. But the Constitution provides for many rights. Most basic rights, like right to life, right to equality, they are given to any person. Not only a citizen of India or the people of India. Suppose you are in India. You are a foreigner. You are in India. Something happens to you. You also have those rights. Anybody in India, any person in India has those rights. Most of the rights. You may not have rights under 19, but you have rights under 14 and 21, most basic rights. The right of religion is there, yes, to any person.
second question, I'm not aware about our constitution in Pakistan, whether there is a provision to decentralize its power to lower courts for ensuring the basic fundamental rights. But as far as the jurisdiction of the Supreme Court is concerned, so for example, it's duty to ensure the basic and fundamental rights of the citizens. But in case of Pakistan, for example, the Supreme Court is taking so much notices of some of the cases. So what do you how will you
so
comment
many
it?
notices are taken by the Supreme Court of India also, many cases. The Supreme Court of India is the most powerful court in the world. There's immense power. No other court enjoys so much of power and over such a vast territory of power and so much of people. 1/6 of human race today is staying in India.
So, court can take and court should take, but some of the cases are taken up to the high level and many cases are remain unaddressed. So is it not more like
That's unfortunate. There is nothing known as high level in cases. Every grievance before a court is important. There is nothing high and low about cases. The grievance of a poor man is equally important as well as the grievance of a millionaire. What do you mean by high cases? I don't know.
No, I mean take to the higher level. I mean
the higher level is Supreme Court.
Yeah.
That is what I am telling you. That you need not go to Supreme Court. That is what is provided in the Indian Constitution, 32(3), which is not normally noticed. The Constitution, the framers thought that Parliament can empower any court with the jurisdiction of the Supreme Court. You're right, it is beyond the reach of the common man.
Sir,
Why don't you come up a little bit? You are not left out here. Sir. Yes. What is your question?
yes. Sir, I'm from Bangladesh, Pakistan. I've been practicing in the Supreme Court 26 years. And I have huge respect for you. First of all, let me share my...
Thank you. I have similar respect for you. All
Yes,
of you are,
sir.
all of us are working in the same direction.
True, sir, but where you are working very effectively in the field of human rights as a commissioner, and we have your landmark judgment on some particular issues as well. Saying that, I just would like to know, sir, how do you see independence of judiciary? Ever do you, when you were in the judiciary as a judge of the Supreme Court, did any time it hampers with some political kind of bias, sir? To be honest, that's because you are not...
I'll give you a very honest view. I was associated with the judiciary for 18 years. Starting from 94 to 2012, and I have been in different high courts and ultimately landed at the Supreme Court and retired from there. According to me, threat to independence of judiciary in India lies from within, not from without. If today you find that the independence of judiciary is in some way threatened, it is because of the judges themselves, the way the judges are conducting themselves. If the judges are strict, the judges are independent, nothing can touch them. Even if something happens, that is bound to be remedied. I don't know about judiciary in other countries, but I think in Pakistan also, whatever has happened, then it is people's fight, led by Mr. Munir Malik, the present Attorney General of Pakistan. The restoration has been restoration of the judicial supremacy. If the judges are strict, how could that fight continue? Because the Chief Justice, I think Justice Chaudhary, never relented, never gave up his position. If the judges are firm and the people find that they are working for the benefit of the people, there is no threat to their independence. If the judges are not firm, the judges themselves are vulnerable, then who can say? Yes?
Sir, my name is Govind Sharma from Nepal.
Yes.
I'm practicing in the Supreme Court of Nepal. I mean, there are many issues, but I'll be asking you two questions.
Yes.
I mean, especially your experience. We have National Human Rights Commission. We are planning to go for the federal system. Still, we are not federal. So we have only one National Human Rights Commission, which is a constitutional body. It is empowered by the Constitution, not by the statute. You know about Nepal's National Human Rights Commission, which is on the paper pretty strong. It has a lot of power. However, the recommendation of the NHRC are not being implemented. One of the big problems, the NHRC itself says that 86% recommendation of NHRC have not been implemented by the government of Nepal. But that's not the true, because if you see that the 100% it is a recommendation for the prosecution, 100% is non-implementation. They also recommend for reparation and other compensation. So they just put all together and it becomes 86%. I mean, your experience working in this, after your Supreme Court's tenure, you are working as commissioner. So how do you make sure that your decisions are implemented? That is my first question. Second, I mean, it's up to you whether you would like to comment on it or not. Since we are having our Chief Justice as the chairperson of the Council of Ministers now, which is a huge issue in Nepal. And, there is a question of independence of judiciary, which our colleague from Pakistan, Bangladesh, were trying to say in her context, but in our context, it's a terrible situation. So, the second is optional, but I would
I'll try to
love to
answer
see the
both the
first.
questions. I'll try to answer both the questions. The first question is the non-implementation of the recommendation of the Human Rights Commission in Nepal. I think the same thing, the same fate has is visited the recommendation of the West Bengal Human Rights Commission. Many of the recommendations of the Human Rights Commission, the most important ones, are not implemented by the government because they are directed against the Chief Minister. They are directed against the Chief Minister, they are not implemented. Many people have questioned me, asked me, then why do you exist if your recommendations are not implemented? My answer is that it may not be implemented, but the recommendation of a Human Rights Commission create some impact in society. It is uniting the civil society movement. It is by consolidating the civil society members and their movements for justice. They can say that as against one individual who is either a farmer, a marginal worker, a daily wage earner, when that person is insulted by the Chief Minister,